My name is Monty Schultz. I'm a licensed clinical social worker in Prescott, Arizona. I'm also a licensed independent clinical social worker with a Nebraska license. I appreciate the opportunity, Senator Fincham and Representative Cashiel, that you chaired this type of hearing. I've seen these issues. I've been a social worker for the last 14 years. We just moved here 2 years ago, and I didn't think that I would be involved in this type of hearing again, as this issue is nationwide, right? And you are taking the initiative to address some pretty significant problems with the family court system. I've been through
Mr. Schultz, you moved here from
Nebraska 2 years ago.
Okay, and I think what I hear you saying is you moved away from a similar problem to a similar problem.
This court is this issue is nationwide, in my opinion, right? I mean, I've testified as an expert witness in Virginia. I've been involved with the TI system in Colorado. I've been involved with it here as well, even though I choose not to work with children anymore, and this is one of the reasons I do not. In my humble opinion, I do believe children are being abused in this system, right? Kids have rights too, right? And we are, in many, many cases, taking fit parents out of the lives of our children, right? And it's done as a grift for the court system. It seems like, as I've experienced the system here in Arizona, I'm watching it as, or seeing it as, we appoint these TIs. Are they really mental health providers, or are they investigators, right? And if they're investigators, do they have the credentials to investigate? This bill 2256 was regarding parental alienation, which is something that should be considered abuse, right? So if they're investigating parental alienation and not reporting this to the agency that is statutorily required to investigate abuse and neglect, who's the investigators, right? So here we have a problem with the family court system. We had another individual come up and say that judges are not statutorily required to
make a referral?
Make a referral for child abuse. Thank you. There's a moral problem with that, right? These are individuals who are first lawyers, who are probably statutorily required to do this, and become judges. Who's getting rich within our system, right? It's lawyers, and in Arizona, it's TIs, right? This is a grift. I bill insurance for my services. On average, I make from $60 to $110 per session, right? I'm glad with that. I'm okay with that. These people are making upwards of $300 per session, right? And they can't bill insurance because it's court ordered. You know, but however, I'm not sure that that's really accurate, because I've had people that have attended my sessions with me that are court ordered to be in therapy, and insurance companies pay for it. So it's really the issue of how much they're getting paid.
Monty, it just occurs to me, if I think I hear you saying that to hide behind the court order aspect of ordered therapy may relieve a therapist from having to abide by certain insurance company requirements or regulatory requirements?
Absolutely, yes.
Okay.
When you're credentialed with an insurance company, you agree to provide services
within guidelines.
within their guidelines.
Okay.
Mr. Chair, usually it's called customary, usual and customary fees that the insurances will pay. And so therefore, what I'm understanding is that they charge so much more, therefore they would not get paid because it's beyond the usual and customary fees.
Well, beyond that, here's the real issue with the insurance. If the insurance company is willing to pay $100 for your services and you bill $300, there's no mechanism to collect the other two because that's against the insurance guidelines.
Exactly.
Right? So therein lies the grift. Right? If you are doing this for a fee for service and you're charging $300 for this per session with, so then you're making 3 times the amount of money. Right? And again, the kids are the ones that are losing out in this. Right?
To your point, thank you for rescuing me on the term. I appreciate it. Okay, Monty, we've got 2 minutes for you to finish up. If you would put a bow on this.
Okay, here's the thing. We're talking about GALs earlier and GAL training. We're talking about training for TIs. We're talking about training for lawyers. If you and you established this in your bill 2256, right? You have to look at where they're getting that training. More likely than not, it's all at the same place. And so they're all like-minded, right? And so are we going to end up in this situation of repetitive problems with the family court system because they're all receiving the same training and there's nobody from outside the system able to work within that to provide a check and balance for the TIs that are currently doing this, the lawyers, all of this, right?
Would it surprise you to know that there nowhere in Title 13 is there reference to a criminal act called parental alienation?
No, it would not surprise me at all.
So that perhaps explains why certain individuals are not duty bound to make a report because there is no such crime.
However, there is a crime for psychological abuse. However, right, it's almost impossible to prove that. My wife worked for Health and Human Services for 20 years as an investigator and as a supervisor for juvenile parole and abuse and neglect. 0 cases of psychological abuse. in
Well, and
20
I
years.
think to that point, it's being used as a weapon
Yes.
to say that they're basically weighing psychological abuse or parental alienation versus physical abuse in a lot of these cases.
Absolutely, and it seems like to further that, it seems like the court system is appointing these TIs as case managers versus using the judicial system to solve the divorce and custody issues.
I'm going to throw a hypothetical at you, and if you prefer not to answer it, I'd appreciate, just be very frank. If you are an individual making a recommendation to the court about somebody that the court has asked you to look at, a recommendation for therapy or extended something, I don't know what all the options are in your world, would it be inappropriate for the court to turn around and order you to provide that care?
In my opinion,
For failure of an arm's length transaction?
in my opinion, yes. Right. And here's the reason why, is because if the court is ordering me to provide a service, I'm providing that service. The court is supposed to regulate coercive practices in family court. At that point, are they doing that?
Mr.
Thank you.
Mr. Chair, I have a question.
Representative?
So in your opinion, I have heard from various parents, but that these TIs have immunity, and the explanation that these parents have received, why do they get immunity, is because that nobody else would do the job, so they need to have immunity. Is that what you've heard, or is that what you have seen?
That's what I've heard, and I don't understand. If they were practicing within the guidelines of, say, the APA or the NASW, why do they need immunity?
That's my question.
I don't have immunity.
Yeah. Okay. Thank you.
That's perhaps one of the most interesting observations made today. Why? All right, members, any further questions?
I have
right. Thank you,
I have
Mr.
a
Schultz.
question, Chair.
Senator Hatotley.
Thank you. Thank you very much for your testimony. My question is, how are these fees, how are they assessed when we talk? And you made a reference regarding, or well, you didn't, but the prior individual did, how individuals have to submit their finances. Is there a correlation between that information that's submitted and how these court appointed advocates or advisors, which also include the TIs, do they use that as a way to establish their fees? I don't, that's what I want to know.
I don't know the answer to that question because I'm not a TI, nor will I be a TI for the reasons I've talked about here.
Thank you.
Okay, members, any further questions? All right. Thank you, Monty. I appreciate your testimony. Just, I suppose, an observation. Once again, we go to this question of quasi-judicial immunity, and I would substitute authority for immunity, and the delegation. Now, there's a non-delegation doctrine for the legislature. In fact, that where that came up is the Chevron deference opinion out of the Supreme Court, that the legislature cannot delegate its responsibility to agencies. It occurs to me that, and perhaps this is something for the legislature to take up in the next session, why then are judges permitted? I mean, these are supposed to be the arbiters of, neutral arbiters of questions of law and fact. Why then are they delegating responsibility? This is tracking well with what you had suggested, that perhaps they're case managers, they're not actually offering therapy. They're acting more like traffic cops to send people off to get out their checkbook and pay for services. Sorry, that's an observation. I guess one of the questions that I've got for you tracks along with the idea of a guardian ad litem or representation for the child. Because I think what we've heard so far is that this is all about the adults. Yes. I've not heard a single person talk about the kids, not one, other than parents. So that gives me grave concern about the focus of the family court orders. Do you think it's appropriate, or should it be, in your professional opinion, should it be the state's responsibility to appoint a guardian ad litem, I hate to use guardian ad litem because that's got a very specific connotation, but representation for the child in this? Once the court has entered into this therapeutic regimen, it seems like there needs to be somebody representing the interests of the court. If you would mind commenting on that before you walk away.
So I'm not sure that, okay, the typical term guardian ad litem usually means attorney, right? Other states expand that a little bit and will allow professionals in my field to serve as like advisors to that youth, right? So I don't know if it's, again, if it's a good thing or a bad thing. Because again, you have to look at where these individuals received their training for family court, right? And it seems like in Arizona, there's not very many places, and they're using one specific place.
Okay.
Well, and really quick, Mr. Chair, to that point, if we start talking about getting a guardian ad litem, we need to be really careful. There's a lot of research done that a lot of times they're not even talking to the kids. Right. There's a whole documentary, Undercovers, that specifically looks at how the corruption is right in the middle with that person. So we would definitely, I think we need something, but we would have to definitely regulate that and really know what we're dealing with.
And who's going to pay for it?
Yeah, true.
Okay. Thank you, Bonnie. I appreciate it. All right, next up,